Sexual harassment is illegal and not tolerated in any workplace. It's estimated that 50% of women and 20% of men have experienced sexual harassment at work. Sexual harassment can inflict serious damage on an organization's productivity and morale. And managers named in sexual harassment complaints could lose their jobs, their reputations, and even their careers. In addition, managers who fail to prevent sexual harassment or who engage in sexual harassment themselves can be found personally liable in court. There are two types of sexual harassment: quid pro quo and hostile environment. Quid pro quo occurs when a manager or supervisor withholds or awards job benefits on the basis of sexual favors. This includes work assignments, hiring, termination, promotions or demotions, positive or negative performance reviews, or any other job-related benefit. Quid pro quo sexual harassment is a serious offense. Just one instance is usually sufficient for a plaintiff to win a lawsuit. One single mistake could end a manager's career. Managers and the organizations they work for can be held liable even if a threat was not carried out or if a threat was only implied. For instance, a manager who suddenly blocks a subordinate employee's promotion after that employee asks the manager to stop rubbing her shoulders could be guilty of quid pro quo sexual harassment, even though there was no verbal threat of adverse employment action. Enduring harassment as a condition of employment is another form of quid pro quo harassment. This type of harassment is often seen in office romances. Consensual sexual conduct is not illegal. However, there is a fine line between consensual and non-consensual in a relationship between a manager and a subordinate employee. In these situations, the subordinate employee can be made to feel that engaging in the relationship is necessary to remain employed. Even if this was not the manager's intention, it's the perception of the employee that is most important to the courts. Enduring sexual harassment as a condition of employment even occurs when the manager is not the harasser. For instance, it's unlawful for a restaurant supervisor to tell employees to put up with lewd comments and inappropriate touching because it's part of the job of being a server. The best way to avoid quid pro quo sexual harassment is to make objective, job-related personnel decisions and keep personal and professional lives separate. At work, every decision should be made based on job-specific criteria. Avoid compromising situations whenever possible. Keep office and conference room doors open and blinds raised in office windows. Hold meetings with groups of employees or in public areas if the subject matter is not confidential. Keep conversations on job-related or non-personal topics, and keep physical contact limited to a handshake. When traveling, meet with employees in hotel lobbies and dine in public restaurants. Planning ahead will help avoid misperceptions. Just one incidence of quid pro quo harassment is illegal and should be reported immediately. Hostile environment harassment occurs when a pattern of sexual conduct unreasonably interferes with an individual's work performance or creates an intimidating, hostile, or offensive working environment. While a single, isolated incident does not generally rise to the level of illegal harassment, severely inappropriate behavior, such as the touching of an intimate body part, can be illegal the first time it occurs. Sexual harassment does not need to be sexual in nature. A pattern of harassing conduct based on gender can also be illegal. This includes harassment based on sex, sexual orientation, gender identity, gender expression, and transgender status. Hostile environment sexual harassment can occur between employees of the same sex, between employees of different sexes, and between employees of any rank or position in an organization. Inappropriate conduct can create a hostile work environment, even if it is not directly targeted at the individual making the harassment complaint. Sexual harassment does not just happen between coworkers. The law covers harassment between employees and non-employees who work in the workplace. Non-employees include unpaid interns, independent contractors, and employees who are contracted from third-party companies to provide services in the workplace. Additionally, harassment can be perpetrated by third-party workers like vendors, facility security workers, visitors, and even customers. Sexual harassment can happen anywhere that employees represent their organization, including work parties, dinner with clients, conferences, trade shows, sales calls, and charity events. Sexual harassment can occur during virtual meetings, telephone calls, email, text, instant messaging, or any other communication, even if the harasser, victim, or both parties are working from home. The courts use the reasonable person standard when determining if offensive conduct is illegal. In other words, would a reasonable person find the behavior severe enough to create a hostile work environment? The fact is that most sexual behaviors, when they are continuous and unwanted, meet this standard. The safe way to avoid sexual harassment is to avoid these behaviors entirely. The following behaviors are unacceptable in any workplace and could lead to illegal harassment: unwanted flirting, repeated requests for dates, and sexual propositions; sexual gestures, whistling, leering, and catcalls; long stares and sexually suggestive looks; using crude or offensive language; physical assaults or threats, intimidation, or physically blocking a person's movement or ability to work; making jokes or comments about a person's physical attributes; gossiping or spreading rumors about sexual topics, or engaging in sexual conversations that are overheard by others; unwelcome physical behaviors such as shoulder massages, hugging, and back scratching; the use of demeaning or offensive names such as honey, sweetie, hottie, baby, girl, boy, or hunk; viewing or posting sexual pictures, magazines, posters, videos, or images; sending sexually explicit texts, emails, or instant messages; viewing sexually based websites and the use of social networking sites for sexually based messages, pictures, or videos; making derogatory jokes or comments about a person's sexual orientation, gender identity, gender expression, or transgender status; making inappropriate remarks or jokes about pregnancy, childbirth, or medical conditions related to pregnancy or childbirth; offensive gender-based comments or behaviors that demean people simply because of their gender, such as a woman's place is in the kitchen, not the boardroom. What is the manager's role in preventing harassment? Preventing harassment starts with managers and supervisors setting the example. A manager's actions are the single most important factor in preventing harassment. Always take sexual harassment seriously. Managers should never tell or laugh at inappropriate jokes or comments, even when they think their employees will not be offended. Follow the organization's policies and procedures and ensure that employees follow them as well. When managers don't follow harassment policy, neither will many of their employees. Make sure that employees understand that organizational policies still apply when they are working from home. Be cautious when using social media. Comments, pictures, or videos placed on a manager's personal social media pages can contribute to a hostile work environment, especially if other employees are part of the manager's social network. Periodically inspect the workplace for objectionable items, artwork, and behaviors. A manager's presence in work areas can greatly reduce inappropriate conduct and catch minor problems before they rise to the level of illegal harassment. Often, a discreet reminder by a manager is all that is needed to stop inappropriate conduct. Remind employees that for less serious conduct, it is helpful but not required to tell coworkers that their behavior is offensive and unwanted. Because managers have a duty to stop harassment before it becomes illegal, employees should be encouraged to report incidents of inappropriate behavior before they become severe or pervasive. Make sure that employees have a copy of the organization's harassment policy and understand the options available to file complaints. Incidents of quid pro quo harassment and severely inappropriate actions, such as the touching of an intimate body part, threats, or intimidation, must be reported immediately. Once harassment has been reported, employers are obligated to investigate it, regardless of how the complaint was submitted. Upon receipt of a harassment complaint, it's critical to listen carefully, remain objective, refrain from offering opinions, carefully document all the facts, and immediately report the complaint to your employer through the proper channels. Contrary to some popular beliefs, most complainants are not looking to get someone in trouble or win a large settlement. They just want the harassment to stop. Give every employee involved in a harassment complaint as much confidentiality as possible. However, warn them that in the process of an investigation, some information will be revealed to others involved with the case. It's illegal to retaliate against employees for making or participating in a harassment complaint. Even if the complaint is found to be without merit, the participants are protected if they had a good faith belief that harassment occurred. This means that managers and employers cannot punish or discipline employees for filing or participating in a harassment complaint. Likewise, non-management employees cannot bully, harass, intimidate, or threaten coworkers for participating in a harassment complaint. Warn all employees involved in the case that retaliation is illegal and will not be tolerated. If the accused employee and the complainant work in the same department, separate them until the investigation is complete. Make sure the complainant is not given an unwanted job transfer or less desirable work assignment to avoid retaliation charges. Investigate all harassment claims promptly and thoroughly. If it's determined that harassment occurred, take immediate steps to stop the behavior and ensure that it doesn't happen again. Apply discipline quickly and fairly, and compensate victims for any losses they incurred as a result of the harassment, such as wages for unpaid time off or restoration of sick leave and vacation time. Both harassment and retaliation can result in disciplinary actions, including written warnings, suspension, demotion, and termination. Sexual harassment often affects future career advancement and may even hamper the ability to be hired by another organization. The loss of personal reputation and trust with coworkers, friends, and family can be devastating and life-altering. It's every manager's responsibility to create a safe, comfortable environment for all employees, a workplace free of harassment and fear, and full of respect. Managers who take this duty seriously not only will avoid legal trouble, but will create a healthy, productive work environment with high employee morale as well.